Welcome. This is Christy Graham and Jackie Cannon again, and we're going to talk about some family law issues that are a little bit more specific because, gosh darn it, there's some questions I have about how to best support the families that I'm working with. Jackie, can you tell me what is harassing and threatening language?
Yes, I come at this from a family law perspective. I'm not a criminal attorney. We certainly refer out when anytime there's like crossover in the family law world to criminal law, but there is definitely some crossover, especially when you're talking about harassment or threatening language, because that really can affect a case, especially when it comes to a protective order. Um, so harassment is actually defined by the Texas Penal Code. It's Texas Penal Code 42.07. You can Google that. It will literally pull you up the actual statutory language that gives you kind of the overall construct. Now, everything in law is subject to interpretation. We all know that. We love to play in the gray area versus just black and white. But what I can do is just kind of highlight for you really on a family law perspective, because I think that's where a lot of you and your colleagues kind of hang out in that territory and what constitutes harassment. Um, Texas Penal Code states that there's a laundry list of it, but it's the intent to harass, annoy, alarm, abuse, torment, or embarrass another. And then it talks about certain behaviors that fall within kind of that category. The main one that we see a lot in family law is going to be sending repetitive communications or phone calls, particularly that don't really have any sort of necessary basis to discuss children or maybe reference a property. Phone calls at 3 a.m., 4 a.m., 5 a.m. Had a case where somebody was sending 300 plus text messages over the course of 2 days.
Oh,
So there's no bright line rule, like how many text messages or how many phone calls can you make before it's going to constitute a violation of the penal code. And I think a lot of it is contextual. If I text you 10 times today, but it's all relating to our child, that's not necessarily going to fall within the definition of harassment. But if I send you 10 text messages and I'm calling you vulgar names and telling you that I'm going to make your life hell and I'm going to come by your house and, do all kinds of things to you, that certainly can bleed into that harassment. So it's very subjective, but it's also very particular on the type of behavior that you're doing. Um, Another one that we often see, especially nowadays, is tracking somebody. And previously, that wasn't really a carve out in the penal code. But it's since been added where it talks about the tracking of personal property or a motor vehicle. Um, it's a little strange versus, okay, well, what do you mean tracking personal property or a motor vehicle versus tracking the person themselves? And I think kind of where it starts to get an issue in family law is, okay, well, what about the use of a PI? Because it can also be not just you following or tracking the individual or the motor vehicle or their personal property. It can be you hiring somebody to do that.
okay.
So there becomes concerns in our line of work. What if we have a PI, and they're following the vehicle? Does that count as a violation of 42.07?
Mm.
Um, Often, I can't tell you how many times I've had somebody who gets sent the child with a tracking device in the diaper bag.
Mm.
Um, or they've turned on some secret tracking device on the child's phone, not necessarily to track where the child is, but because they want to know where the other party is at all times.
Mhm.
Numerous instances of having tracking devices placed on cars.
Mhm.
So that is becoming more and more prevalent in the code. The penal code is finally starting to address that.
Mm.
as well as because it can become stalking behavior in a sense as well.
Yes. So here's where so there's not any like bright line, but as a family law mental health professional, someone who works
Mhm.
a mental health professional who works in the family law sector, we lots of times refer to BIF. Our communication should be brief, informative, friendly, and firm. So if we stick with BIF, then we're probably not going to be sending um, yucky emails or
Mhm.
texts or messages that are mean or anything like that. Although we can sneak in the odd pot shot, I guess is what you're
Yes.
saying. But how concerned do judges or other people get about those pot shots that are in the middle of an informative um, email? Is that just a therapeutic kind of concern, or do judges get concerned about that as well?
Judges do get concerned. Sometimes the concern is a safety concern, depending on the language or the tone that's used. And I'd say probably more so it's on the co-parenting. How can you co-parent with somebody when you're like, hey, wanted to let you know Johnny came home from school sick today, and the response is, okay, let me know, by the way, you're a whore. Those there's no legitimate reason for adding that in, but it's amazing how many people make little digs like that in there.
Mhm, mhm.
Um, and a lot of times what you'll see is kind of the more innocuous statement. Well, if you don't agree to this, it's going to get real rough for you. Okay, well,
Mhm.
what does that mean? What I'm thinking may not be what you're thinking. And if this person has a history of domestic violence or more outwardly threats, then the person receiving that statement is going to have a more kind of threatening response to it,
Right.
scared, concerned, than someone who gets that and they're like, okay, what are you trying to do? Yeah, if we have to go to court, neither one of us are going to like it.
Hmm.
So some of it becomes subjecting, but I think it really depends on the history that the two people have between each other. And is this a person who, out of 100 messages, 99 were appropriate and one, they just had a bad day and had a really kind of bad filter on at that point?
Mm-hmm.
Or is it somebody who sends 100 messages and out of those 190 of them are just constantly throwing in little jabs at the other person? Because it's really hard to co-parent with somebody that's constantly taking jabs at you. And
So, Jackie, what do
though,
you tell your clients when you're starting to see your client? I know we love to think that all of our clients are perfect, but they
yeah.
aren't. You know, everybody has a bad day, like you were just talking about. But when you start to see that on, say, OFW, or you hear it from the other attorney that your client is starting to do those kinds of threatening or harassing things, what do you counsel your client to do?
So it depends on the client. Some of them I've recommended they need to seek counseling because they're just having difficulty kind of accepting the process. There's a lot of hurt feelings or anger at the other person. It is very difficult, especially if you've been married. I tell people I can end your relationship as husband and wife, but you still have to carry on as mom and dad. And a lot of people have difficulty compartmentalizing those two things.
Mm-hmm.
Yes, he may have been a terrible husband, but he could have been a great dad. Those two things are not mutually exclusive all the time. So it's something where depending on the level and the way that my client is addressing it themselves, it may be that they need therapy to address some of these issues that they're having. Certainly sitting them down and talking with them about the repercussions and how it could certainly affect their case, whether they're wanting 50-50 possession of the child. Well, I don't know any of our judges that are going to give 50-50 to somebody who can't co-parent and uses their communication in a way to harass the other side
Mm.
or to kind of inflict some sort of emotional, payback on them for any slight that they feel that parent has done to them.
Okay. Okay. Um, wow, this is great information. Is there anything we haven't talked about that is really helpful here?
So threats are a completely different section.
Oh,
And really what it comes down to is a terroristic threat. That's going to be Penal Code 22.07. Um, and terroristic threats can be, threatening somebody with actual physical violence, calling in a bomb threat to a public building,
mm,
um, something along those lines. Not every threat necessarily is a terroristic threat. It really just depends on the context and if it meets the statutory requirements. But threats can also very much be harassment, depending on, again, the context and the nature of the threat itself. Um, so there's certainly two separate provisions in the code, but harassment can encompass threats that may or may not rise to the level of terroristic threats.
okay. So if you are saying you whore and then saying I'm gonna take you to court, that doesn't lead to terroristic threat, but it does start to sound like a threat.
Yes. So it can be a threat, but it hasn't become terroristic threat. Terroristic
Okay.
threat would be they're never going to find your body because I'm going to take you and chop you up and spread you around Denton County.
Mm,
That can start to become a terroristic threat because you're threatening somebody with serious bodily injury or death. Um,
okay.
so again, it's really about the context of when it was said, how it was said, and the language in itself that was used. Obscene is another one where obscene language is very subjective. What I view as obscene may not be what you view as obscene, may not be what a jury or even a judge views as obscene. Obscene is actually defined in the penal code, but again, a lot of these things are we always like to say the rational person, but it's hard to determine exactly what a rational person is at times.
We've been trying
Um,
to come up with a definition for that for a while, hasn't
and
we?
yes, and what a rational person was 10 years ago was totally different than what a rational person is today. Um, but for some people, cursing can be obscene. For others, obscene is if I, send you a text message with a pornographic image of male genitalia and tell you what I'm going to do with it, that can be determined as obscene. But the person who's sending it oftentimes doesn't view that as obscene.
Oh,
Um, so sometimes there's just some clarifications and some mental health work that need to go on with people to realize that just because they don't view it as obscene doesn't mean the person receiving it does not view it as obscene. The other thing to keep in mind is the Denton County Standing Orders apply to every family law case. So whenever a case is filed, they're automatically attached. A lot of these are also encompassed by 2.1, 2.2, and 2.3 of the Denton County Standing Orders. So it could not only be a violation of the penal code, but it could also be a violation of your Denton County Standing Orders by sending obscene, threatening, harassing messages, making repeated phone calls for no legitimate purpose, those kind of things. So certainly in the context of one is criminal in nature, and then one can be a violation of the Denton County Standing Orders, which itself can be punished by jail time, a fine, and paying of attorney's fees.
okay. Okay, so that's not just going to end up being money. It could also be jail time.
Yes. And it has happened. I will tell you there's some interesting arguments about whether it's violation of First Amendment rights. We have a lot of people who like to talk about whatever's going on in their life and their case on social media. There's been some cases that have come out and said you can't prohibit somebody from posting about, a case on social media, talking about it, those kind of things. But um, I think that's just something that's going to have to play out in the court systems. Of how limiting can it be? It's kind of like you can't yell fire in a crowded theater. There will be limitations on conduct and on speech, but I think again it's going to be contextual. If you're posting horrible, obscene messages like revenge porn statutes are now a thing.
Yes.
Um, you're posting online on Facebook groups, making threats. Even I've had it where somebody has posted a meme depicting them killing the other party. Um,
That seems a tad threatening.
yes, and so the question then becomes, okay, that was just posted on a normal Facebook page. It wasn't made and sent directly to the client. So is that enough to be perceived as a threat when it wasn't conveyed to the client themselves? So again, it's all contextual. A criminal attorney could certainly better handle any aspect on the criminal side of it. But from a family law side of it, that even plays into whether or not there's the potential for a protective order, because it could be perceived as a threat, especially if I knew that person would be looking or seeing it.
Right.
Although
Or
I
their
didn't specific
family.
exactly. So because conveying a threat through a third party, me handing you my phone and saying, "Hey, call Sally Joe and tell her that I'm going to be watching her and she needs to watch her back," that can be conveyed as a violation of harassment because I've literally had you do something on my behalf that is harassing behavior. So some people try to get away with some of this by using other people or posting it on like a group, like a city Facebook page, or these weird kind of parent groups that have been created all over Facebook. Um, but in my opinion, especially in the context of family law cases where the risk of family violence is very high during these cases, um, and it's really traumatizing for a victim or for somebody who's just doing their best to try to protect themselves or their child to constantly have to be watching over their shoulder. So I think some of it is on attorneys to do our best to get our clients under control, um, minimize the harm or damage that can take place. There are clients that unfortunately they just don't listen no matter what you
Yeah.
do.
I will say
Um,
that as a parent facilitator and a therapist who works with parents and children, for me, what is really important is to have the attorneys convey their clear concerns to me. And sometimes I think that's difficult given your advocacy role.
Yes, we walk a delicate line of trying to not only advocate for our clients, their positions, our concerns, but also doing so in a way that still maintains attorney-client privilege.
Yes.
Um, I've had that issue quite a bit when it comes to parent facilitation, when the facilitator wants to talk to us and ask us questions. Well, you know, have you talked to your client about this? And, kind of more details that we don't necessarily have the ability to convey, which I know can hamper the process in some regard. But it does make things difficult on our end too, because we want to be helpful, but we're also doing our best to maintain that attorney client privilege in order to protect our client,
Is
but
there
also get them help at the same time.
is there a phrase that you use with MHPs that is a good clue that we've asked something that you can't answer? Like I mean I know I've had attorneys say, "Oh, I can't answer that." But I know you don't like to do that because it feels yucky. But is there other ways that you kind of convey to us that role? Because, we MHPs don't know all of the rules that you're going under. And sometimes we take things as if we're talking to another therapist who should be sharing openly and
Mm-hmm.
freely. You guys don't have that same freedom.
No, it could cost us our law license by divulging attorney-client privilege. So usually there's sometimes I just don't know, and I'll let people know I don't know. I don't have an answer for you. But I don't like to beat around the bush. I'm a very kind of forward person, and I'll just let you know, unfortunately, I can't provide you that information. Um, because one, I think it's helpful for you if it's very clear and conveyed to you that, hey, this is an area or topic that we can't get into. especially if there's current pending criminal charges. That's where a lot of these things start to become an issue.
Yes.
Is, people get frustrated because we've told our clients, don't talk about this. There's potential criminal charges that could be brought, or there are already current pending charges that have been brought, and they're not allowed to talk about some of these topics. And so I know that gets frustrating on y'all's end because you're like, okay, but this, I need to know these things in order to help these people. But at the same time, we're like, our clients definitely cannot talk about these
Yeah.
things.
So
So
do you
that's
prefer for parent facilitators to pause parent facilitation when there are pending criminal charges? I mean, that's kind of been a conversation that me and some of the other MHPs I know have is that just an automatic parent facilitation is not safe for both parties? I mean, if there is domestic violence and this person hasn't been to BIP yet, are they going to be doing things in parent facilitation that are inappropriate and more traumatizing? Or could that bring up information or put them at a legal liability outside of parent facilitation? I mean, I don't want to put people at legal risk either.
right. I don't typically do parent facilitation when there's been domestic violence. Um, I think it depends on the comfort of the client.
Mm,
But a lot of times they're not really comfortable being around that person. We've tried to put a lot of safety rails in place so that their communication and their exposure to that person is minimal. A lot of times we're talking with criminal, and the crossover would be if there's like a DWI charge or a DUI charge or drug possession, something that not it doesn't necessarily affect co-parenting. But if the concern is, well, I'm concerned they just got arrested for drunk driving, this is their third one in the last 8 years, and how can I ensure that they are being safe and protective of the child and not drinking over there? That's still an area that we're telling our clients, you can't talk about that.
yeah.
You can't go into those because every little thing that you say can be used against you. So even, telling my client as simple as don't admit to how much you drink because you have these pending or possible pending criminal charges, because that can all be used against you. And a lot of it is just communication. Sitting and having a conversation with the parent facilitator and saying, hey, I don't want these particular areas to be discussed because it's got to be shut down for my client.
Right.
So a lot of it is just communication, making sure everybody's on the same page as well.
Mhm.
Because the last thing we want to do on our end is ask for a parent facilitator to be removed because they're not respecting boundaries, but you may not know what those boundaries were. So,
Right, right. Thank you so much, Jackie. You've been so helpful and so informative. I'm really excited about being able to share this with my other friends and with people who are really interested in figuring out how to stay within the right realm. What I'm probably going to add to this is if you could give me links to the 2 or 3 legal places that you talked about. I'm going to also link Biff, the Bill Eddy book, which is about
okay.
brief, informative, friendly, and firm. And then we'll put that all together so that when people get this, they can go, oh, that's really helpful.
Yes, especially with the penal code, because it is laid out pretty
Yes.
clear. And it definitely includes a lot more things than I've covered today.
Yeah. Thank you so much. I appreciate you, Jackie.
You're welcome.